What is a partnership? Can anyone define partnership for me? Uniform Partnership Act defines it. It's defined as an association of two or more persons, to carry on as co-owners a business for profit. An association, two or more persons, to carry on as co-owners a business for profit. We're going to see how that plays out. There are several types of partnerships, and there are reasons to evaluate between them. There's the general partnership, which has unlimited liability for everyone. There's a limited partnership, which has limited liability for limited partners, general liability for general partners. There's a limited liability partnership. I have one slide on it because it pertains to law firms. Law firms choose that because it has limited liability for corporate debts, but unlimited liability for malpractice. And that's necessary because most bar associations don't permit lawyers to hide behind a liability shield, and so you need to choose an entity type like a professional corporation or an LLP where there is liability for malpractice. So you can't avoid that liability. There's also some issues about fee sharing with non-lawyers, which is why most law firms are not corporations. There's also something called a limited liability limited partnership. Just don't worry about it. It's not useful anymore. It's been basically supplanted by LLCs. The two that you'll have to worry about are GPs and LPs, general partnerships and limited partnerships. Of course, this course is mainly about corporations. And if you want to think of these things as a spectrum, corporations are one end of it and partnerships on the other. We're going to see some of those really specific differences. Unlike a partnership, which has no real substance without its partners, a corporation is wholly separate from its shareholders. It's a completely separate entity, and as a result, a lot of different management structures, a lot of different liability provisions, different control rights, different liquidity rights, different withdrawal rights. Corporations, like partnerships, also come in several different flavors. Most of what we're going to be talking about is called a C corporation. This is sort of your standard corporation. A C corporation has something called double taxation. It's taxed at the corporate level. Corporate profits are taxed. And then when those dividends are paid to shareholders, that's also taxed. It's called double taxation. You can avoid that by making an election called an S election, and you would then have an S corporation. However, there are some limitations on when you're permitted to make that election. There's also an election to be a closely held corporation. That mostly has to do with management obligations, fiduciary duties, and things like that. So we're going to see that a little bit more next semester. It's a little bit out of the ambit, but we need to worry about for now. And there are also some nonprofit corporations. We're not going to talk about those at all. They don't have shareholders. That's basically all you need to know. They're not part of this course. We have an entire other course on nonprofit corporations. A lot of different rules, a lot of different fiduciary rules. We're going to learn about the fiduciary rules to shareholders who are owners. Nonprofits don't have owners. Completely different set of fiduciary rules because who would you owe those duties to? But that is a type of corporation, a not-for-profit corporation, 501c3 they're often formed as. And we're also going to talk briefly about social benefit corporations, or B corporations, which are really a kind of like USDA organic. It's still Celerate, but it has a stamp on it. We're going to talk briefly about those. But the key ones you have to know about, going back to what's really important, are just distinguishing what is the difference between a C corporation and an S corporation. When I say corporation, I mean C corporation. That's the default, that's the normal, that's the average, that's the majority of this course, right? A separate entity. If I want to talk about S corporations, I will say about that specifically. And the difference is just tax. It's a different tax structure. It's a partnership tax structure. So as we talk about our planning, we'll talk a little bit about tax, and we'll talk about the S election briefly, 10, 15 minutes. But it doesn't change our governance provisions. And then our third and newest type of entity is a limited liability company, or LLC, and it's a hybrid of these two forms. In fact, it can look and feel very much like a partnership or very much like a corporation. So it's a very flexible entity choice. It's useful for a number of different things, but before you gravitate, there's sort of a the goal for this is you get the points in the exam. You know, some students tend to want to suggest a limited liability company for everything because it's flexible. Well, flexibility comes at a cost, literally. In order to form an LLC, you have to think through a lot of things which are standard provisions in any other entity. So it's not the default choice in all cases. It's not the default choice in all cases. You only really select the LLC if you need the flexibility or if you're trying to achieve a corporate tax structure without the corporate tax. You want the corporate governance structure, but you want to pay a partnership tax, and for whatever reason you can't form an S corporation. Because LLCs are so flexible, they can be cumbersome to form, cumbersome to govern, and outside investors are particularly wary because you don't know what you're getting when you buy a unit of an LLC unless you really carefully read the operating agreement, whereas a corporation is pretty standard. You don't have to learn about each corporate form. If they're standard and they're ordinary and there's nothing weird about it, you kind of know what you're getting in terms of rights. But since LLCs are so flexible and customizable, it can be hard for outsiders to know what they're getting. So it's not a great choice for people who are looking to obtain a large amount of outside funding for that reason. LLCs also have a couple choices, a couple flavors to them. LLCs can be formed either as a member-managed LLC, and a member-managed LLC looks like a partnership, or a manager-managed LLC, which looks more like a corporation, where you have a board of managers. And so we're actually going to learn about the partnership and the corporation, and in that way you'll understand the LLC because it can have elements of either. It just costs a little bit more to put it together because it's a little less standard. And it's been around for a much briefer period of time, so there's more uncertainty about liability for an LLC. There's just not that many cases. The first LLC statute was 1996. Corporations have been around for hundreds of years, so there's just a lot more case law in corporations. So it's a little hard to say what you're getting when you get an LLC in terms of what courts will do. Yes?
What about a professional corporation?
A professional corporation is similar to a limited liability partnership. It would be useful for an accountant or a law firm, but they would be they would have a board of directors like a corporation does, but they would allow liability for malpractice. So if you want to frame in terms of the LLC, it's kind of, the LLP is more like the partnership, is more like the member-managed LLC, whereas a professional corporation is a corporation, but it has liability, it has additional liabilities which may be necessary in order to achieve that. So, for example, I think I've mentioned I have a very small and not particularly successful consulting company. Hopefully one day when I have more time, can actually earn money and not just take losses. I formed it as a professional company. Why? Well, I was able to make an S election. I'm a sole shareholder. There's some simplicity toward it. It was simpler to do than forming it as a partnership. The documentation was much more standard, easier for me to make, easier for other people to understand. It's just me. Right, and it's actually also a closely held business, so there's fewer obligations for meetings and things like that. And I still have liability for malpractice through that corporation. That's the professional part of the corporation. But I enjoy a liability shield for debt. So if something that sort of issue. But some law firms form as professional corporations. Most form as LLPs. Part of that is just stickiness. PCs are a little newer. They're not available in every state. Mine happens to be formed in District of Columbia, and I looked at the statutes because I'm a nerd. And, I actually read the statutes. I preferred the default rules that came with it. Most people would just choose something off the rack. So let's talk about partnerships. There are several types of partnerships, as I just mentioned. General partnerships, where all the partners have unlimited liability. Right? So that sounds dangerous. In fact, it is. The reason that we talk about general partnerships is not because you'll form them. You often will not tell your clients to form a general partnership. I'm very wary of the liability issues that come along with having a general partnership. If you're going out in the world, there's a real risk of committing torts or incurring debts, and very problematic if the founder has full liability for that, or even someone who's a 10% partner to have full liability. I mean, if you contributed 5% of the capital into a general partnership, you're fully liable for all of its torts and debts. That can be scary, risky, and problematic. So some people prefer the limited partnership form. Limited partners have limited liability. They can't lose more than they've invested in the business. There still has to be a general partner, so that's important to recognize. There's a general partner who has unlimited liability and a limited partner. So you can think of it as a GP-LP kind of structure. And we'll come back to this in a minute, but actually there's a way to get around the liability for the GP too. You form a corporation, the corporation is the GP. We also, as I mentioned, have LLPs and LLLPs, but I'm not going to worry about them right now. So let's define it again. What is a general partnership? This definition is important because you'll find that you can actually form them by accident, and that's where it really comes up on the bar. It really comes up on the bar because people have gone into business for profit, and they didn't file anything. A general partnership does not require a filing. A general partnership is a voluntary association of two or more persons to carry on as co-owners a business for profit. It doesn't say two people who intended to form a partnership. It doesn't say they filed a document with the Secretary of State of the state of Pennsylvania. It simply says that when two people associate to carry on as co-owners a business for profit, they have created a general partnership. They may have done so unwittingly. And we need to look out for that, because if our clients come into us and they are already carrying on a business, they both have unlimited liability for each other within the scope of that business. It's also the most basic type of a partnership. You don't need anything to do it. You simply go into business with someone, and that is a partnership. It's a default regime. But it might be one you want to avoid because of unlimited liability. A limited partnership, as I mentioned, is comprised of one or more persons who control the business, and that'll be the general partner, and one or more persons who simply contribute capital and share in the profits, but have nothing to do with the management structure. Nothing whatsoever to do with the management. In fact, as we'll get to in a second, how that works out depends on the law. I'll get to that when I get to that. All right. Here's a map of the states that have adopted a uniform law called the Uniform Partnership Act. And as you can see, there's actually a lot of homogeneity on this act. So model acts, you probably are familiar with them from the Uniform Commercial Code. Model acts are statutes created by the uniform laws or some other body, and they go around the states trying to encourage the states to adopt this as state law. As we know, corporation law is state law, partnership law is also state law, right? It's a state entity. It's all about state laws. It's not a federal law class at all. So what laws have the states adopted? Well, fortunately for us in our study of this, almost all of the states have adopted a fairly modern version of the Uniform Partnership Act, including Pennsylvania. We'll actually find Pennsylvania is a weird outlier in basically everything else, but at least they're middle of the road on this one. And the name of that statute is the Revised Uniform Partnership Act of 1997. You can abbreviate that RUPA, R-U-P-A, RUPA. And that's pretty consistent, and you know, you'll see there's going to be a lot of parentheticals here, but when you see RUPA, that's the Revised Uniform Partnership Act. That applies to Pennsylvania. It applies to the vast majority of the states. The rest of them have adopted the Uniform Partnership Act of 1914, if you're just interested in trivia. Right, so in North Carolina, their partnership law dates back to 1914, essentially, as a uniform law. All right, so let's talk about RUPA, and let's see what it has to say. RUPA says a partnership, shock, shock, is an association of two or more people to carry on as co-owners a business for profit, formed under Section 202 precedent law or comparative law of another jurisdiction. So, what section should we look at to see how a partnership is created? Let's take a look at 202. 202 again says it is created by the association of two or more persons to carry on as business as co-owners of business for profit. That forms a partnership without any filing. And in fact, RUPA goes so far as to clearly state that they form that partnership whether or not they intended it. Intent is completely irrelevant to the formation of a partnership. If two people are associating, two or more people are associating to carry on as co-owners a business for profit, they have formed a partnership under state law in the vast majority of states. And by the way, Uniform Partnership Act said something very similar. So that means a partnership can be formed by accident, and that means that partners can be liable for each other without even realizing it. Yes?
So is there a regularity requirement for this? Because oftentimes people will engage in things where they make money together for brief periods of time. Like when we were younger, my brother and his buddy, they would mow lawns together in the neighborhood. Mm-hmm. Could that constitute a partnership?
Absolutely. You and your buddy get a lawnmower, borrow a lawnmower, and you walk around knocking on doors and charging $5 to mow the lawn. You have formed a partnership. And if your buddy runs over somebody's garden hose and causes a flood, you are liable for that damage, even if you weren't there at the time.
Even if you're 16 years old?
So that's... I haven't seen that case. Certainly if you're 18 years old. We've been sentencing children to prison for far worse, so I wouldn't be shocked. There's nothing in the statute which has an age requirement, but I think I think courts would be reasonable. I haven't seen the case. So for now, we'll talk about adults, or at least 18-year-olds, if they will constitute adults. But that's exactly right. Two 18-year-olds go around the neighborhood offering to mow lawns. They have formed a business. They have formed a partnership. And if one of them damages somebody's car while hauling that lawnmower around, the other is fully liable for that damage. And you can see how this would be a real risk. I mean, your buddy might not have $5,000 to fix somebody's, Porsche 911 that you just put a saw blade through the window or whatever, right? And they can come after you for that. Absolutely. That's what unlimited liability means. Yeah, Joanne.
Is there an endpoint to this? Like, operation?
Yes, we will talk about how a partnership ends. A partnership can be dissolved, there can be withdrawal, and partnerships tend not to last forever, right? So that is one important component, and that's where we get to the continuity concept. How do we end a partnership? And any partner, and the short answer is if either of the two partners says, I'm not interested in this partnership anymore, under the old law, that would cancel the partnership. Under the new law, that person is no longer part of that partnership and has a right to be paid out. Yeah. There probably are a lot of dangling partnerships just hanging around, but there are some ways to officially kind of cancel it. All right, so I had the question again here. I should stop asking this. Can a partnership be formed unintentionally? Yes, it's fundamental to know. It's on the bar like every third year. Always comes up. Someone, two people are doing business, and people are missing that because they're like, well, they didn't file anything. You don't have to file anything. You're liable. Two buddies with a lawnmower. One runs over the garden hose. The other might have to pay for it. So let's talk about some of those features, and let's walk through those different aspects of how a general partnership would work. So by the way, I'm always referring in this section to RUPA. The Uniform Partnership Act of 1914 is a little different, but since it's a tiny minority of the states, I'm going to focus on Pennsylvania law wherever I can here. We'll get back to Delaware law next week, 2 weeks from now. So what's the general default rule? Well, first off, by the way, everything I say here is subject to an important caveat that you can create an agreement to do almost anything. But we're talking about a partnership that is formed without an agreement. Two guys on a lawnmower is the best example haven't come up with. Better than any example I've come up with, right? Because you can really get the intuitive sense about that. They probably didn't sit down and hammer out a partnership agreement. So they're probably bound by default rules as found in the statute. So under the default rules, again with the caveat that they could agree differently, how is it governed? Equally. Each partner has an equal right. Doesn't matter if one provided the lawnmower and the other one just provided, what's a much less expensive part of lawn? The rake. One brought the rake and one brought the lawnmower, right? Lawnmower costs how many more times than a rake? 50 times more than a rake? 20 times more? Substantially more. So you have one person who's a 95% contributor, one's a 5% contributor, but if one brought a rake and one bought a lawnmower, they both have equal governance rights. It's not based on how much they contributed. Everyone at the partnership table has that equal vote. If you've ever been at a law firm, you'll see this is true also. You have equity partners who are making $17 million a year, others who just got promoted to partnership, but at that partnership meeting, it's one person, one vote. That's the default. And ordinarily, decisions are made by majority vote. So it's just a matter of majority, which means, by the way, what happens if you have two people and they don't agree? Nothing happens. It's a problem called deadlock. And so deadlock can actually lead to dissolution. If we had more time to talk about partnerships, we could look at some of those cases. And I'll just mention, though, a good partnership agreement, to the extent that you write partnership agreements, you might for a limited partnership. Although rarely nowadays you see people forming general partnerships with formal documentation, there should be a provision to deal with deadlock. You may not want that partnership to dissolve automatically. But bottom line, GP control, one person, one vote, majority rules, and if you reach a deadlock, it can end up in dissolution. Finances default a little differently. This is more probably what you would expect. So partnership accounts are a little complicated, and you probably don't want me to stand up here and talk about accounting for 45 minutes. Thanks. Because I don't know if I have that much content on general partnership accounting. It's complicated, as is the tax structure. It's a flow-through tax structure, and you'd have to take a really advanced, you would learn basic income tax, corporate tax, and usually partnership and LLC tax more advanced than that because it's more complicated. But in terms of how much you get profit-wise, each partner contributes something of value. So we have the rake and the lawnmower example. And then they're described as having their own account. And so the way this works is that this account or this balance, you add the contributions and you add their share of profits. And those share of profits, unlike the vote, are based on your pro rata contribution. So if the rake is 5% and the lawnmower is 95% of the total contribution, the person who, without other agreement, the person who contributed the lawnmower would have more rights to the distribution. Although, of course, you can agree otherwise. It doesn't have to be formal. I mean, when you go into business with your buddy and you go out in your lawn care business, you probably have a conversation about how are we sharing the profits. And so, again, that's an agreement. You don't have to even have that written down. This is not as important as the liabilities. Usually it's the liabilities that really matter to people because they suddenly get hit with a bill they didn't expect. And as I mentioned, if you bring a rake to this enterprise, you are now a partner. And if that other partner causes damage, you can imagine you could do a lot of damage in a business, right? You're driving around with heavy equipment. Yeah, you got it, whatever. And so there's a lot of liabilities that can be had. So the liabilities are unlimited for each, regardless of how much you contributed. And so that's an issue. There is one exception. So it's sort of just a minor rule, but and I'm not going to test on this, but the bar likes to test on the quibbly little rules. The one that they usually get to is that if a person only contributes their skill, doesn't bring a rake at all, contributes none of it, then they're not liable for the debts. So just sort of a minor rule, and you can see that in example 6.7 on page 145. Just take a look at that, and when you get to the bar exam, something to think about. In that example, A and B form a general partnership. A contributes all the capital, all the equipment, and B only is doing the work, only mowing the lawns. When the business produces losses, A cannot force B to contribute to those losses because he is not a capital contributor, and so it's sort of an all or nothing. It's been a very contentious rule, but it is still the rule, and it's something that comes up from time to time outside of this class. So the rule here is that partners generally share jointly in profits and losses unless otherwise agreed. Doesn't matter your contributions, joint sharing. If one partner contributes only capital and the other contributes only labor, then that person is off the hook. They're not going to be responsible. Yes?
So you said joint sharing profits and losses, but then what about that account you were talking about where you each have pro rata contributions?
I think I confused that. I apologize. Let me reset. The partnership account works that this is how much the partnership owes you. And so that's based on your contributions. And so if this will come up in a minute when I get to withdrawal. So when you bring a $5 rake to the business essentially owes you the value of that rake. That value is added to your book. And if you receive a distribution of the profits, that's subtracted from the amount that the business owes you. And so we kind of maintain that balance in that way. Like if a company makes business, it might leave it in the bank account. If a partnership makes money, it might leave it in the bank account, or you might say, I'd like my share. The share is usually 50-50 unless otherwise agreed. So how much of that you're entitled to. So there's a different concept between your account and your share that you're entitled to. So I see some confused faces. The fundamental thing here is in a partnership, things are 50-50. You have one vote. You have one. If there are two people in a partnership, they have 50-50 rights to vote, 50-50 rights to control, 50-50 rights to profits, 50-50 obligations toward losses, regardless of what they brought into the business. That's the more fundamental concept. I should have led with that. In addition, there's a concept of a partnership account. And so when you bring something to a business, that's added to what the business sort of owes you, and then as you take that share of profits, that's deducted from how much the business owes you. So we kind of maintain these partnership books. And again, as I mentioned, I kind of glossed over the accounting because we're not going to really deal with that. The fundamental thing, again, liability, unlimited liability for everyone who brings any capital to the business, and this notion that unless you agree otherwise, everything is 50-50, or 33-33-33, or 25-25-25-25. It's all equal unless otherwise specified. And unfortunately, so is liability. Which partners can be liable? All of them, any of them, regardless of how large their contribution was. So illustration 6.2, example 6.2 illustrates that. So if you looked at page 141, it says that A provides capital, the money, right, the equipment, and controls the day-to-day operations in B's custom automaking business. A receives a share, A shares control, doesn't have total control, has some control, and a share of the profits, not all the profits, when the automobiles are sold. And so this is a partnership. A and B are engaged in a business together. They're associating for the purpose of making a profit by making cars. So if B agrees to build a car for X, but disappears and breaches that contract, A is completely liable. They are both completely liable, joint and several liability. There is one limiting factor, is that only pertains to things that are within the scope of the business. So A and B are partners. They're in the business of making cars. There's a lot of things that go into making cars. You might order supplies, right? You promise to pay $10,000 for a windshield. So that bill comes due. Someone has to pay it. Both people are liable for that bill. Someone might try to buy a car from you and you don't make good on the promise and they sue you for breach of contract. Contractual liability there as well. In the process, you might build the car wrong and someone gets injured as a result of that. It's tort liability. Both are liable for that. That's all in the scope of the business. But let's say your partner goes out and goes to Chuck E. Cheese with his kids and starts screaming profanities in the ball pit. Something wild like that. Right? Trying to lighten things up a little. Glad. Thank you. You all paying attention? So you've got your partner screaming profanity in the ball pit at Chuck E. Cheese, and he's arrested for this. Are you liable? No. No, that's not within the scope of the business. The business is making cars. It has nothing to do with Chuck E. Cheese, at least I assume so. And as a result, that's not going to be something the other partner is liable for. So it's only things that pertain to the business where we create these liabilities.